Hey, it's James, Father's Rights and Resources, hashtag how I got custody. While I'm thinking about it, there's a bunch of legal principles you should know going into court in order to keep stuff out of court that should never be allowed in court. Inadmissible evidence, for instance, you guys should all know the rules, the evidence rules or rules of evidence in your state. If you're in Florida, just Google Florida evidence rules or rules of evidence. Washington, rules of evidence. You need to know all that stuff. And even if you have an attorney, you want to know that your attorney's doing their job. In a football game or a basketball game or soccer game, the coaches and players know the rules. They don't just trust the referee to know the rules, because if a referee misses a call, a player's going to say, hey, he fouled me. Hey, he hit me when you weren't looking. Hey, didn't you see that pass interference right in front of your face? Or look at the instant replay. So, even though you're a player and you have a coach, which is a lawyer, the players sometimes yell at the referee and say, hey, you missed this call. You should know you're going into the game of family court and the arena of family court, and you're going to play the game. You should know the rules too. A lot of attorneys say, oh, just trust me, trust the process, this and that. Why would they want you to be totally blind to what's going on? The attorney is supposed to, under the rules of professional conduct, which you should know, there's a whole bunch of stuff you guys should automatically know as a baseline thing. Rules of professional conduct, the statute that governs your rights, or what the factors the court has to consider. Best as a child, which parent is willing to facilitate a relationship with the other parent, which parent has performed parenting duties and parenting functions, the bond between the parents, all that kind of stuff. You should know the rules of evidence, because if the other side, let's say the mother's attorney, keeps testifying and keeps talking about child psychology, that's inadmissible and the court shouldn't even listen to it, and the court's listening to it and they're winning because of that inadmissible testimony. You should be shutting that down and keeping that out. Or your attorney should. And if your attorney's not doing it and you know the rules of evidence, you can lean over your attorney and say, object. Object, personal knowledge. Object, ER 403. Object, irrelevant. Object, expert testimony. You should be leaning over and telling them that stuff. Just like you would lean over and tell the coach, hey, coach, look, they missed that call. Have the coach yell at the referee so you don't get an unsportsmanlike or whatever. So, among the things that you should know to keep stuff out, you got the rules of evidence, things that attorneys can't do under the rules of professional conduct. Another thing is these doctrines of estoppel. There's 3 of them, and they kind of mean all the same thing, but they do it from different angles. So people can't go to court and relitigate something that was finalized at a trial a couple years ago. If the mother comes to court and said that you were a child abuser in the divorce, and then she goes back to modify a couple years later, or let's say domestic violence. She said you committed domestic violence against her, and at trial in 2022, the court didn't find domestic violence. And now she's coming to court, and you don't ever talk to her or see her. You pick up the kid at school, so she can't even attempt to claim domestic violence now. And she'll say, oh, the father was domestically violent during the marriage. You can say, objection, that was already litigated and over with at trial, and the judge concluded there was none, so she can't go back and relitigate it. Most of you people know about double jeopardy. Once you're found innocent of a crime, you cannot be re-prosecuted for that same crime. That's double jeopardy. The state has one shot at it, and if they blow it, that's too bad. That's their problem. Before he passed, the state can't re-prosecute O.J. Simpson. He was found innocent of murder of Nicole Brown Simpson. They could never prosecute him again. So, civil court has a similar doctrine that criminal court has. I think in old Europe, in some pockets, they used to prosecute somebody and lose and prosecute again and prosecute again. And they actually would have court hearings and not give somebody notice, and they wouldn't even know there's a court proceeding. That's why we have those due process things in place, because the founding fathers had experience in older Europe about things that weren't fair. That's why we have the Constitution the way that we do. And if we followed it, everything would be great. But let's say this example, the mother says that, you would say, objection, collateral estoppel, judicial estoppel. Collateral estoppel means, I remember because, when there's a bomb and the bomb hits the ground and then there's collateral damage, when somebody comes to court and they drop a bomb in court, there's collateral damage and it affects you, it harasses you, it traumatizes you, it inconveniences you, you got to spend money. So she is collaterally stopped from the collateral damage of taking you to court because she already litigated it. She shouldn't be able to bring that out. She could come to court for a modification on other reasons, but she can't bring in subject matter that she lost before. So, objection, collateral estoppel. She's relitigating something that's dead and over with. That saves a hassle for the people who are collaterally, who suffer the collateral damage of somebody going to court or making that allegation. Then there's a doctrine called judicial estoppel, which is to protect the judge or the court from wasting their time. They don't want them to relitigate in order to protect the judge. So it's the same thing, but it's saying who's being protected. Now there's a doctrine called res judicata or res judicata. People pronounce it differently. That's where you went to trial. Now, if you settled out of court, this doesn't apply because the judge never got a chance to hear everything. So in a lot of states, it's open to relitigate something that's old if you never went to trial. But if you went to trial and went in front of a judge, the court has a chance to make a ruling and fix it and finalize it and all that stuff. Res judicata says if somebody could have brought up an issue a couple years ago or a few months ago or whenever in court and did not, they're stopped or banned from bringing that up in another proceeding. A different example. Let's say the mother, your ex-wife, never asked for alimony in the divorce. You went to trial and you had child support, custody, and all that stuff. And then a year later, she's like, man, I'm broke. I can't survive. I'm trying to go back to school. I'm trying to get further educated so I can get a real job or whatever. Or a better job. You could say she had her chance to talk about, and she motions to court for alimony. She had her chance to talk about alimony during the divorce. She didn't. We went to trial. It's too late. So res judicata says if there was a previous proceeding in which you could have brought something up that's not, it's not brand new. It's not a new issue that was never brought up. But it's an issue you had a chance to or could have brought up in a previous proceeding. You're banned from bringing it up now. Like if somebody tried to get a restraining order against you in January and now it's April and they say everything again and they say, well, also I found out he was trying to reach out to me back in December. You had your chance to prove that in January. So res judicata, that bans them from doing that. So collateral estoppel, judicial estoppel, res judicata. You have to understand this. It's basic fundamental legal 101, along with the rules of evidence, along with the statutes. And then also every parent should know Troxel versus Granville. If you don't, go watch my YouTube video. If you don't understand these things that are complicated, you are totally lost even more than the average person. And you need to get a one-on-one consult with me. The average person will look at my videos and say, dang, this is exactly what I need. My attorney won't talk like this. Nobody's giving me answers. James give me answers. I need to talk to him. But only like 1 out of 100 people will do that. 300 people watch a video, I get a few calls. And then one of them actually wants to have a consult. If you know you're totally lost, why wouldn't you get help to figure out what the hell is going on? Because we're talking about your life with your child. We're talking about going to court and fighting for the result and fighting for an order that dictates your life with your child. Why would you not want to learn it? If your child has a sickness or disease, there's a lot of parents out there who are just as well versed on a disease or a disability as the doctors handling the kids. Because why? Because they love their kids and they care about their kids and they research it because they're responsible for their kids 24 hours a day outside of the doctor's office. So if people do that with sickness and disease or, with your car, you learn everything about your vehicle that's wrong with it when the mechanic says, oh, you got, the way that you handle your car, you're bad on the brakes, so the rotors go out really fast or whatever. Then you want to learn about how that stuff works and you'll learn some of the stuff that the experts know so that you can apply it. Why won't you learn everything you need to know about your court battle that dictates your life with your kids? This is why everybody needs a consult with me. Everybody needs several consults, but guaranteed, bottom line, everybody, even to get going, needs at least one consult with me. So consider doing that.